Well, good evening, everybody. Thank you very much for joining us, thank you for these fabulous surroundings. I hope you all agree how amazing it looks. My name is Stephanie Kleyman, I'm sure you all know that, and I am a commercial solicitor with 24 years experience. This evening's seminar was called, If an apple a day keeps the doctor away, how do you avoid an employment law solicitor? But I could easily have called it an idiot's guide to employment law, but the reality is we're not idiots. Often the reason why things go wrong is that people just don't know what the law is and what they need to do in order to avoid an employment tribunal claim. Often when people come to see me, it's already gone wrong because they don't have the right contracts in place, they don't have the right procedures in place, and by that stage it's often too late to put it right. So I thought that I would provide people with some basic documents and a bit of advice about how to avoid an employment tribunal claim, because prevention is better than cure. Now you've all got an envelope that's got some handouts in it because I thought it was easier than people taking notes, so you can doodle on them, you can graffiti them, you can use them for paper aeroplanes, whatever you feel is appropriate. But this is aimed at employer-employee relationships, people who have self-employed staff, who perhaps have workers, subcontract work out to people. This doesn't apply to them. That's a completely different type of relationship, and if anybody wants to talk about that kind of relationship, then I can help them out at a later stage. But if you've got employees, there are certain procedures that you should go through in order to reduce the risk of a claim. People often talk about contracts of employment, and often when they come to see me when there's a dispute, they'll start by saying there isn't a contract. Well, there is always a contract. What they mean is it's not in writing. There are 6 or 7 basic facts that have to go in the contract. Who you're employing, who the employer is, what your salary is, where you're going to be working, what your hours of business are, what your job title is. The statement of terms sets out the basics that should be in every contract. It can be something as simple as a letter. It doesn't have to be anything complicated. There are circumstances where you might want restraint of trade clauses, you might want confidentiality agreements, there might be complicated bonus structures, but you don't have to have it. If you're just employing, say, routine staff to do an everyday job, the statement of terms will cover everything you need. And there's no point in making it any more complicated than it has to be. And as long as everybody knows exactly what their terms are, there is much less likely to be a dispute. Disputes almost always arise because people just assume that everybody else knows what's going on, and because there will always often be misunderstandings, that's when people will fall out. My draft statement of terms includes an opt-out agreement. This is because under the Working Time Directive you are not supposed to work more than 48 hours in a week. Averaged out over a 2-week period. The reality is that often we do, but if you consistently ask your staff or expect your staff to do more than those hours, you will be in breach of the Working Time Directive. So I always suggest that people ask their staff to opt out, but you can't force them. If they say no, you cannot make them do it, in which case you just cross that bit out.